Yeah, my name is Matt Cagle. I'm a technology and civil liberties attorney at the ACLU of Northern California.
So great. So you were on the panel this morning on privacy, and what did you take away that was most surprising or striking in the discussion with the other panelists?
Right, so we're at a time right now where digital systems and digital platforms, everything from Facebook to Google to online advertising, have become interwoven into all of our lives. And folks are grappling with things like the Cambridge Analytica fiasco, data breaches, and the misuse of personal data. So there's a shared awareness that something needs to happen, but there's a disagreement about what exactly that needs to be. So this morning's discussion was a really interesting deep dive into this recent California privacy law and sort of competing ideas of what are the ways in which we can make sure that consumers are informed and have control over their data while enabling innovation.
Now, traditionally, I think the ACLU has thought of themselves as we're being concerned about government intrusions on privacy and other liberties. But here, often, it's the government trying to actually protect privacy, whether they're effective or not. And it seems like some of these large companies are potentially violating privacy. How does the ACLU see that triangulation between companies, individuals, and the government?
Right. So traditionally, the ACLU has worked and continues to work on the preservation of constitutional rights, civil rights and civil liberties, freedom of speech, privacy. And 100 years ago, this was primarily advocacy and litigation that was focused at the government. But in the past 20 years, we've seen so much of our personal data go into privately owned servers, everything from our emails to our contact books to our sensitive health data. And we've also seen modern free speech, modern expression take a home on places like Facebook and Instagram. So the ACLU's role as an advocate for civil liberties and civil rights has had to evolve to look at the ways in which digital systems and privately owned systems play a role. When the government wants to obtain data about a user's Facebook account, they have to send a warrant to Facebook. So they play a role in this sort of preservation of civil rights and civil liberties. Deciding when regulation is proper and when government intrusion into sort of the debate is proper is a really difficult question. I think it's most important that these be decisions that are decided in a democratic way, that it's not just lobbyists for industry in the room making decisions about what a bill looks like, but that there are folks there representing the users and the consumers, and that this process, this democratic process is playing out in a robust way that results in outcomes that we all agree are the right ones.
And let me ask how the phrase data governance came up today, or privacy governance. And so that the question I'm thinking about is how can we make those decisions in a meaningful way? One way to make the decision trivially is to agree to conditions that you haven't even read, which really leaves the substance in the hands of whoever wrote those conditions. Right. But what do you think is a constructive way to make sure that people are really informed and engaged in managing their privacy?
Yeah, I think we all agree that privacy policies and terms of service have become so long, onerous, and numerous that they are not the best way right now to inform all of us about where our information is going and how it's being used. There's a movement, and this was discussed at today's panel, to really instill as a start into the DNA of a company and the product development cycle, the idea that privacy should be designed into the product, that you should minimize the collection of sensitive data unless it's totally necessary to what you want to do with your product. This actually does serve the business interests of companies. If you have less data, it can't be breached, it can't be hacked, it can't be misused by advertisers. If you secure it and encrypt it, maybe it's encrypted and then breached in a way that is indecipherable to those who have obtained the data. So taking steps beforehand can save you PR headaches, but also real money when you get, when these things happen, the FTC or lawsuits might come your way. And so to run an efficient business that can grow quickly and scale, it's important to just work these things in earlier.
So do you think liability generally, whether tort liability or fines, has a role in pressuring companies to take into account these considerations?
I think that, and we think at the ACLU that privacy laws like the one that was recently passed in California, they need teeth. They need a private right of enforcement so that a consumer who has been harmed because of data practices by a company can bring a legitimate lawsuit to incentivize compliance. There are laws on the books, privacy laws included, that they don't have these provisions or they have weaker ones. Mm-hmm. And when there isn't that sort of incentive there, a reasonable sort of provision that allows consumers to seek remedy, when it doesn't exist, there's little incentive to comply with these laws, and then they're just paper on the books. So it's important to find the sort of happy medium where companies and industry are incentivized to comply early and to really build privacy into the products.